Hello, this is Pamela, the Divorce Mystic. I'm a 25-year intuitive attorney, mediator, and coach who's integrated a spiritual practice into my business. And for our time together today, we're dealing with part one of a larger series dealing with child custody. What is the best interest of the child? What does it mean, and how is it used? To start us off, we need to recognize there's two forms of child custody. Child custody in terms of legal custody, who's going to make decisions regarding a child, what school they go to, what doctors they go to, what extracurricular activities they can participate in, what religion they're going to participate in. Those type of decisions are under the umbrella of legal custody. Where a child resides, whose care the child will be in, and at what times and for how long, those are legal physical custody decisions. So we're dealing with them both when we're dealing with child custody. So to understand that a child custody case doesn't make its way into a court unless the parties bring it to the court. And why I preface that first is simple. The reasons that a case is brought to a court is because the parties forget in most cases. And after 25 years of representing parties in divorce, I can tell you parties forget that they are the most important adults in their children's life. They know the most about their children, and they therefore are the best parties to determine what is in the best interest of those children. So to bring a custody case to a court and say we cannot by ourselves make a determination on what is best for our children and we need you to do that, that's what sets the stage for how these cases present themselves and what position a court is in when they make their way to them, to their desk. So it makes sense that a best interest of the child, overall standard of the best interest of a child or children is the standard, because you're charged with coming up with a decision that is in the best interest of a child or children that you haven't met, that you know nothing about. And you will learn about that family through perhaps an expert witness, perhaps friends and family members, as well as the two parties. But in a sense, if you think about it, no matter how long a trial is regarding child custody, no matter how many experts there are, whether there's a guardian ad litem that actually speaks to the children and brings the voice of the child to the court through that process, or a expert is hired to do a custody evaluation, and that expert brings a recommendation to the court. Regardless of any activity that may happen, when those situations are presented to a court, think of the animosity and the tension of the two parents who are striving to prove why they're the better parent and the other one is unfit. When you're dealing with legal custody is who's going to make those decisions, right, for those children. And in a case where you've got two pleadings and two parties that filed pleadings that are setting forth why the other party is not the party to make good decisions and they don't have good judgment, etc., then I should be the one to make those decisions. And the other party says the same thing, just in different words. But both pleadings are discussing how bad the other parent is. Think of the position of the judge on that bench. What do I do? Geez, if what they're saying in these pleadings is true, maybe the children should be in foster care. I'm not really sure what to do. So it really puts a tremendous amount of pressure on a judge and the court system when we're leaving them as the decision makers as to what is in the best interest of a child. But nevertheless, they are charged with determining what is in the best interest. So the nice thing about what is in the best interest of a child eliminates what is in the best interest of the parents. So the judge at least has a freedom to, it's not important what's important to you guys as the parents. I'm just focusing, dead on with what's important with the children in this particular case. How do they determine that? How do they know that? And what do they look at? In most cases, or in most jurisdictions, there's a code. So the factors that a court must look at or consider when dealing with child custody matters is usually codified in several factors in their code. I'm going to get through a few of them. Think of what you would do if somebody brought an animal to you. Let's take it away from children, but for a minute. Brought an animal to you and said, out of the two of us, we need you to determine which one is better to take care of our animal. And we're going to give you this piece of paper that has a bunch of factors for you to consider. And then we're going to each give testimony. And then you're going to decide for us what is in the best interest of our animal, in this particular situation. Just right there kind of makes your stomach bubble just a little bit. Oh, I don't know if I want to make that decision, right? It's a lot of responsibility. This is a live, breathing thing. Same thing with your children. Unlike an asset that needs to be distributed or a liability that needs to be covered in a divorce matter, children being the live, breathing flesh asset of the family, it's a totally different situation. And there's not enough pressure by the attorneys and the other professionals involved in the divorce profession itself that puts the pressure on families to let them know that even though you're divorcing, you're still a family. As I say, it's my philosophy that a family is a family even in divorce. It's just a family in transition. So there's not enough pressure put on families to remind them that there's nobody that knows better about their children or what's in the best interest of their child better than they do. And in a situation where there's a divorce, unless there's abuse or some drastic measure that needs to be taken, and one is requiring supervised visits in order to protect the interests of the child, not the parent, but of the child or children, then who is really in the best interest to make the determination as what is in the best interest of a child? Nevertheless, once it gets in front of the court is charged with looking at their state or their jurisdiction's factors of what they must look at to make a determination. So let's start with, what is the status quo? What's happening? So in many cases, one parent may have been more of the time spent as a caregiver while the other one spent more time working. That is one factor to consider, but doesn't make the decision as to whether or not that parent should be the primary parent, or what's the situation, what determination should be made based on that. No. So we look at another factor, right? So what's another factor the court looks at? What is the propensity of one side or the other to foster a good relationship between the child and that other parent? So if you think about the pleadings that are filed, he or she does this and won't do that, and he or she does this, and vice versa, the other one, he or she does this or that. So the judge is looking at this and hearing testimony and is thinking, wow, neither party seems like they're going to be the one who is going to foster a good relationship with the other parent and the child. It's a little risky here. It's a little scary here, right? So let's say that in one case, dad was the caretaker because the mom worked more. But yet, in terms of who's going to foster the relationship better, it looks like mom's a little bit more reasonable and can control her emotions better and understands the value in some ways of, and in many cases, she's able to control her emotions, and she's likely, after the dust settles in the divorce, to be able to foster that relationship. Right? So maybe in that situation, the judge looks at it on mom's side. Okay, now we're thinking the scales of justice here. So those factors, how that information comes to the judge is through testimony, through the testimony of the parties, testimony of their friends and family if they bring them, also professionals that may be hired. Perhaps one of the parties asked for a guardian ad litem. Why would they do that? A guardian ad litem is usually brought into a case if the parents or one or the other thinks that the voice of the child is really important, because in most jurisdictions a child cannot testify There's special occasions where they do, and they're brought in camera, meaning they testify with the judge at his desk in his office, not in a courtroom. But in most cases, children are not allowed to testify until they reach a certain age, and even after that, it's frowned upon, and usually the party that brings the child to testify is not favored well by the judge or the court. So the guardian ad litem meets with the family, meets with the child, perhaps talks to the school, and talks to a teacher, talks to a doctor, talks to somebody, maybe a coach in their extracurricular activities. And they kind of get a feel for the family, get a feel for the child, talk to the child, and based on what they learn, they bring that information to the court and give a recommendation. In many cases, they're attorneys that were trained to be a guardian ad litem. I did that for a while. So it could be an attorney like me, or it could be another professional that the court appoints, as long as they have training on how to be and what their job entails being a guardian ad litem. In more severe cases, the court gets their information through a custody evaluation. So when you hear hotly litigated, very expensive and very emotional cases, a lot of those have hired a child custody evaluation. So an evaluator is appointed, and it's somebody that's a professional in the field, known to testify. So they have their routine that they do, talking to both parties and, again, witnesses, and how they gather their information, talk to the children, and they come up with a recommendation for the court. Based on my professional opinion, this is what I think is in the best interest of the child, right? Still looking for some or factors enough to give the court some assurance that if you make this decision, it's going to be in the best interest of the children, and vice versa. If you make that decision, it's not going to be. So that is how the court learns the information in order to determine. So we've looked at a couple in this video, but I'm hoping that by the time you hear the next version of this, that it's giving you a taste of what it's like. Hopefully it's caught you before you've started the process, and that you understand that unless you're one of those, and if you do need help and you do need a supervised visitation schedule for your child, by all means, nobody's telling you not to do that. That is a personal choice, and you need the help. You need to seek the help that's right for you. But if that's not the case, I'm hoping that this catches you in time to see that putting your children in a situation where someone else is going to decide what is their fate is not as, perhaps not in their best interest as much as you and your spouse, their other parent, making a decision as to what is in their best interest. Parents that remain anchors for their children, and those that, my philosophy is always, family is a family. Even in divorce, it's just a family that's in transition, and it just looks different, but it's still a family. So if you can, for a moment even, adopt that philosophy and sit with it and see how it resonates with you, understanding that nobody knows your children like you. Nobody knows your children like you. So in the event that you can, remove yourself from the court system and parent your child with your spouse and come up with a parenting plan. Yes, you can seek help, whether it's through a coach, through a parenting expert, a child specialist. There's plenty of help out there that doesn't require the court to be able to make a final decision for you. So if you feel like you need help, help is out there, seek it. So until we meet again, I hope this has helped. I hope that it's inspired you to look at your case different, and to perhaps talk to your spouse or find a way to shake yourself and your spouse out of the spell of litigation if you're in it. And understand the industry, be a little bit more educated about the industry, and to know what it truly means when you're putting your children's future, which is also your future, in the hands of a third party to make decisions for you. If you can just notice how precious that statement of your family's still a family, it's just in transition is, then perhaps you and your spouse can make decisions that are right for you and keep yourself out of the system, which not only creates more enduring agreements, It creates a better co-parenting relationship moving forward. And those times in everybody's life, right? Things are constantly changing and evolving. So if you're in a situation where you're making a decision together about your children in the initial stages, then as you're co-parenting and things change, you just pivot and make a change. Just pivot and make a change. You discuss it, you learn to communicate, you pivot, you make a change, rather than what happens to those who do go through the court system for litigation or for custody determinations. When life changes and moves forward and modifications are necessary, what do? They're still fighting, and they're still using the court to make the decisions regarding a modification. So you can save yourself that in terms of money, emotions, time, and truly giving your children what is in the best interest of what is in their best interest, and that's you. That's their parents. So until we meet again, my friend, namaste.